Welcome to our live cast. We're going to be answering some questions, giving you the latest updates.
My name is Kaushik Rianchad. I'm an immigration lawyer. I've been practicing for over 22 years.
Trump's going to join office January 20th. That leaves us a little over a month. So one of the things that we're doing right now is getting prepared for that in our office, prioritizing certain cases. One of them being DACA renewals. If you need to renew your DACA, get prepared to do that. Also, U visa green cards. We're also doing that as well. The Department of State has updated the skills list. This is big news. They haven't done this since 2009, and 15 years later, they have updated it. So it's really important to know what this means, to not be confused. One question is like, do you still need to apply for a 2-year home residency requirement? It really depends upon what the reason is for being subject to 212E and whether or not your country is subjected to the 2-year home residency requirement. For those of you who don't understand what the skills list is for, so when you come here on the J1 program, the whole concept of the program is you're coming here to learn skills and take them back to your home country. But life happens, you might fall in love and meet a citizen or lawful permanent resident. You might want to further your career after being here. You might have had a child here. So then that's why you can apply for a waiver. There's a variety of ways that you may be subjected to the 2-year home residency requirement. One of them is if you've got government funding from the United States government or your home country. Even if your country is not on the skills list, but you have government funding, you're still subjected. Another way you can be subjected if you are a physician participating in a residency program, you may be subjected to the 2-year home residency requirement. So even if you're not on the skills list, that's not gonna matter. Where the skills list does apply is if it's just purely based off of the skills list and you're not subjected in one of the other ways, then you may not be subjected to the 2-year home residency requirement. So you can find that information on your DS2019. Look at the bottom left-hand side of the DS2019. You'll see like why you're subjected. Sometimes they forget to check the box and you're gonna have to dive deeper into that. I think one of the biggest ones that may impact Indians who may not be subjected to the 2-year home residency requirement being on the skills list where you applied for no objection waiver. And that's where you can apply for a no objection waiver and get a no objection statement for your home country. If they're willing, if you were on the skills list, that's when you would apply for a no objection waiver. If you're no longer on the skills list, you may not need to do that. If you filed the hardship waiver yourselves and you get a request for evidence, do we take those cases on? So let's talk about the hardship waiver. As we've been talking about the J1 waiver, if you're subjected to the 2-year rule, you either have to go back or you have to file for a waiver. If you have government funding, you're going to need to file for a hardship waiver, persecution waiver. In many situations, physicians have their own specific unique waivers that they can apply for, such as a Conrad 30 waiver or a VA waiver or IGA waiver. Hardship waivers are one of the most difficult waivers to win. We have noticed an increase of requests for evidence. Maybe it's foreshadowing to the Trump administration. What we notice when we take over a case, usually it needs to be completely rehabilitated. We redo the case because we find when we review what was done before, it wasn't enough. But we can take it over. We have to review the case to see if it makes sense to do that. And you can connect with us at 916-613-3553 to talk about that more. Who qualifies to get a green card as a child? Well, you need to be an unmarried child under the age of 21, and your parent has to be a U.S. citizen to qualify as an immediate relative. That means that you can file your green card right away, and then you're just waiting for the processing time. You don't actually need to wait for the visa bulletin for the priority date to become current. So if you're not an immediate relative, then you would fall within what's called a preference category, and you can find that on the visa bulletin, and I'll show you what preferences you may fall within. You want to look at the visa bulletin as like you're waiting in a line to decide like when your priority date is going to become current. When it's current, file your case if you've maintained a lawful status. If you apply for a marriage-based green card, can you work legally until you receive your approval? So that's a great question. When you file for a marriage-based green card, you can also apply for work authorization. We actually just got a work authorization when we filed a marriage-based green card within less than 2 months. I'm hoping that's a trend that's going to continue. Sometimes it could also just be an outlier situation. You can also file for the travel document while you're filing the green card as well. These are going to get a lot harder to get approved because of the Trump administration's coming in. We expect a lot more requests for evidence. We expect a lot more investigations as to what is going to happen to determine whether or not your relationship is real. If you are committed and you want to stay with your partner for the rest of your life, but you just, for whatever reason, haven't taken the step, you may want to consider applying for the marriage-based green card once you get married. Does my immigrant spouse need his visa interview scheduled before he can apply for an I601 waiver? For those of you who don't know what an I601 waiver is, it overcomes different types of grounds of inadmissibility. So that could be, for instance, certain types of crimes. It could be the 10-year bar. It could be fraud or misrepresentation. So if you're applying in the United States, you can apply for the 601 waiver and the green card at the same time. Right now, the times are taking about 28, 29 months. If you're outside the United States, then you go through the whole immigrant visa process. That's the whole green card process. Get a denial at the embassy, and then at that time, you can apply for the waiver. And when you get the denial, they'll give you like a sheet for what the reason of the denial is. All right, thank you, everybody. Hope this was helpful. If you weren't able to join live, just post your comments below. I do my best to respond to as many of the comments that I can. Thank you. Bye-bye.